welcome to the channel of Lawyer Talks. It's nice to see you today on our new episode of our podcast. Today, we will discuss a topic that is deeply concerning among legal matters on marriage and family, which is cohabitation as husband and wife. This also means men and women living together as husband and wife without registering their marriage. For this matter, please join me in listening to Lawyer Tran Ngoc Thuyet, a senior partner of BLawyers Vietnam Law Firm.
Hello, Miss Trinh, and listener of the podcast of BLawyers Vietnam Law Firm.
In modern life, we often talk about the situation in which men and women live together as husband and wife and simply call it cohabitation. So, from the legal perspective, what is the definition of living together as husband and wife between a man and a woman?
Oh, yes. According to current law on marriage and family of Vietnam, cohabitation, a husband and wife, is when a man and a woman organize life together and consider each other husband and wife. A practice in Point D, Section 2 of Trinh Circular number 01, 2001, issued to guide the former law on marriage and family 2000. Men and women are considered living together a husband and wife when they fall into one of the following cases. Wedding ceremony take place while they live together. The cohabitation is approved by the family of both or either party. The cohabitation is witnessed by other or organization, or they truly live together, take care and help each other and build a family together. The beginning time of the cohabitation between a man and a woman is considered the day just right celebrate the wedding, or the day they were accepted by the family, or the day their relationships were witnessed by another person or organization, or the day just right began to live together, take care of and support each other, and jointly build a family.
So, currently, does Vietnamese law prohibit men and women from living together as husband and wife without marriage registration?
Current Vietnamese law do not prohibit men and women from living together, a husband and wife, without registering marriage. However, in some cases, this behavior will be considered a violation of marriage and family law, including a follow. Firstly, a married person who live together as a spouse with another person, or a married person who live together as a spouse with a married person. This can be considered a serious violation of monogamy. Secondly, Vietnamese law also prohibits cohabitation, a husband and wife, between a man and woman with the same direct bloodline or with the same surname within 3 generations, or cohabitation between adoptive parents and adopted children, and the third, cohabitation, a husband and wife, between an adopted child and a person who choose to be an adoptive father or mother, between father-in-law and daughter-in-law, mother-in-law and son-in-law, or father or mother and stepchild, They are the violation of the law, affecting norm, morality, and stability of family and social relationship. Depending on the special case, the above-mentioned act will be subject to the administrative or criminal sanction.
Thank you for sharing. As per your sharing, I understand if a man and a woman lives together as husband and wife without falling into the case that you have just mentioned, they do not violate the law. So, are they legally recognized as a husband and wife relationship like married couples?
Regarding the recognition of conjugal relation between man and woman living together as husband and wife without registering a marriage, Vietnamese law regulates the three cases just follow. In the case of the man and woman living together as husband and wife before 1987, if they live together as husband and wife before 3rd January 1987 and comply with the condition of marriage but have not their marriage, the marriage relation shall be recognized from the time of starting cohabitation. This is also known as the factual marriage. In this case, a man and woman are determined as living together as husband and wife. If they satisfy the marriage condition of the law on marriage and family 2000 and also fall into one of the following case. There were a wedding ceremony, wife they live together, their cohabitation was accepted by the family of both or either party. The cohabitation was witnessed by another person or organization, or they actually live together, took care of, and supported each other and mutually contribute to family. In the case of a man and woman living together, a husband and wife, in the periods of from 3rd January 1987 onward before 1st January 2001. In these periods, if a man and woman live together, a husband and wife, and make the requirement for marriage registration under the law on marriage and family 2000, but have not yet registered the marriage and are still living together. They were obliged to register their marriage within 2 years from the 1st January 2001 year mentioned above. They shall be recognized a husband and wife from the day they start living together. After such 2 years, if the man and woman have not registered their marriage, they will not be recognized as having a marital relationship between husband and wife. In the case of a man and a woman who start living together as husband and wife from 1st January 2001 onward without registration their marriage, the couple is not recognized as husband and wife under the law on marriage and family 2000. Thus, since 1st January 2001, Vietnam have not recognized a marital relationship for two parties living together a husband and wife. Cohabitation will not give right to right an obligation between husband and wife for the party. However, it should also be not just if two parties live together a husband and wife and then proceed to register the marriage. They have to establish a marital relationship from the time of the marriage registration.
Thank you, Lawyer Thuyet. So, what are the difference of rights and obligations between the parties with marriage registration and the parties who live together as husband and wife without being recognized as a marital relationship?
Oh, very differently. As the law of marriage and family regulate the right and obligation between husband and wife, including personal right and obligation, property right and obligation is right, which is recognized and protected by law. For example, there is an alimony obligation between husband and wife, meaning just one spouse is obliged to contribute money or other property to make the other essential need when they do not live together and one spouse faces difficulty or destitution due to inability to work or not having property in which to live. In addition, the husband and wife have a right to inherit each other property by will or by law. For men and women living together, a husband and wife, without marriage registration, from a legal perspective, they are not husband and wife. So, the right and obligation between husband and wife under the law shall not apply to them, and their relationship shall not be protected by law.
In addition to the marital relations of a man and a woman under cohabitation that we have just discussed above, could you please share your opinions regarding this question? During the cohabitation, if the two parties have common children, can they register the birth of their children? And if so, how can they do this?
Under the law of Vietnam, children born here shall have the same right and obligation as other children, but this does not depend on their parent marital status, including the right to have their birth registered. The fact that the parent did not register their marriage does not affect the child's right to birth registration. If the father and mother of a child have not had a marriage registration, the competent authority cannot record the man information in the father information section, and the father entry in the civil status book and the child birth certificate will be left blank. However, if the two parties would like to have the name of the man recorded as the father of the child on the birth certificate, the father must carry out the procedure of recognition of the father and the child relationship in accordance with the law on a civil status. At that time, the competent authority will handle the recognition and the birth registration.
Thank you for your sharing. Apart from the birth registration as mentioned above, how about the rights and obligations of the parties towards their common children?
As I mentioned above, children shall have the same right and obligation as other children, but the risk does not depend on their parent marital status. Accordingly, the two parties living together, a husband and wife, must perform their obligation toward common children in accordance with the regulation on the right and obligation between parent and the children, including obligation and right to care for, nurture, educate children, represent children, etc. It is the same as the right and obligation just legal husband and wife exercise toward their common children.
Another issue of concern is the common property between a man and woman living together but not registering their marriage. Could you please share more about how to resolve the property relationship between two parties living together as husband and wife?
If the spouse are legally married, the common ownership regime to property between them is divisible, consolidate joint ownership. Consolidate common ownership is the common ownership in which the ownership proportion of each party is not determined. Accordingly, husband and wife had equal right and obligation to property out jointly. For men and women living together without marriage registration, they shall not be recognized as the legal spouse. Therefore, property acquired by each party during the period of cohabitation shall not be considered joint property of husband and wife. The joint ownership of property between them is only considered ownership of more than one party to the property. According to the current law on the marriage and a family, property relation between the cohabitation party will be settled according to their agreement. If there is no agreement, the settlement shall be based on the regulation on a common ownership between many parties, a record in the civil court. However, the law of marriage and a family also stipulates that the settlement of property relation between man and woman living together as husband and wife must ensure legitimate right and interest of the woman and children, housework, and other work related to the maintenance of common life are considered the basic labor.
So, if men and women want to jointly buy apartments, land, and house, how are the certificate of land use rights and home ownership granted, and to whom are they granted?
A man and a woman who have not yet registered for marriage still have the right to agree to jointly receive the transfer, purchase, and sale of real estate and join the name on the certificate of land use right and right to ownership of home and other access attached to the land. The property shall be treated as a jointly owned property. Regarding the issuance of the land use right certificate, Clause 2 of Article 98 of the 2013 Law on Land regulates. In the case of the land parcel with one or more person under common land use right, or how or other access attached to the land with one more person under common ownership, the, the certificates on land use right and home on the work must fully record the name of all the person and shall be issued to each person with its certificate. If requested by user or owner, only one certificate shall be jointly issued to them and given to the representative. Third, men and women living together without marriage registration can still be named together on the land use right certificate. This certificate shall contain the full name of both parties and will be issued to each person in each person. If there is an agreement between the parties, one certificate can be issued together and given to the representative.
Also important to this topic is the inheritance between men and women living together as husband and wife. Can a man and woman be living together as husband and wife be entitled to each other inheritance?
According to the law on inheritance of Vietnam, husband and wife shall be the heir at the first line of the inheritance of each other. Third, they are entitled to inheritance according to law. However, for a couple living together, a husband and wife, the marriage and is not registered, so they are not legally recognized as a husband and wife, so they are not entitled to each other estate under the law, unless the name of one party is designated by the other party to inherit the estate in the will.
Thank you very much. I also would like to ask whether the children of men and women living together without marriage registration are entitled to inherit the estate from their parents.
According to the law on inheritance, the biological children of the deceased are the higher heir at the first line of inheritance. Therefore, children are entitled to inherit the estate of their parents, regardless of the whether or not they were born within the marriage period, as well as whether such children are stepchildren or children born during marriage. If it is proved just a person is the child of the bequeathed person with a blood relation, they will be entitled to inheritance according to the law.
Thank you for your useful sharing. As we can see in practice, cohabitation between a man and a woman without marriage registration also gives rise to a lot of legal disputes, and the resolution of which is sometimes not easy. The first issue is divorce. So currently, could the parties entering into a cohabitation request the court for a divorce or settlement of common property or common children?
According to the current law, Vietnamese courts still accept to settle divorce requests of the two parties living together, a husband and wife, without marriage registration. Accordingly, whether the party mutually or the unilaterally get divorced, the court shall not decide whether or not to accept the divorce, but they will issue a decision on the non-recognition of marriage relationship between the party because the nature of their marriage is not recognized by law. As I mentioned before, regard the settlement of the common children and the common property. If a man or woman request the court to settle child custody or property relation, the following principle shall be applied. Regarding the child custody, the court apply the regulation on right and obligation of the parent and the children of the law on the Marriage and Family 2014 to settle dispute, and regard the property relation, the court settle according to the agreement between the party. In case the party cannot reach an agreement, it shall be settled in accordance with the regulation of the civil code and other relevant law. However, the settlement of the property relation must ensure the legitimate right and interest of the woman and children. In addition, housework and other work related to the maintenance of the common life other consider bad labor.
Yes, thank you, Lawyer Thuyet, for providing a lot of useful and very important information for today's topic. I am sure that our listeners will have a better understanding about cohabitation, which is the situation in which men and women live together as husband and wife, but have no marriage registration.
Thank you, Mrs. Trinh, and our listener for discussing with me such a practical and intimate topic in social life. Hopefully, through this podcast episodes, our listener will find useful information for yourself and the family.
Thank you very much for your sharing today, Lawyer Thuyet. Hello everyone, time's limited and our podcast today would like to pause here. Thank you for listening and for your interest. If you have any questions or concerns, please leave a comment below, or for more information about BLawyers Vietnam, please visit our website at the link below. Goodbye and see you soon.